Be ready? 5 seconds to go. Start. Learned APP Miss Gadhvi submitted that there is sufficient evidence to convict the applicant accused for the offence. So there is concurrent findings of two lower courts and there is no reason to interfere in the judgment of trial court and the appellate court. So the revisional court has limited scope and in the absence of any perversity in the judgments of the courts below, this court may not set aside the said judgments. So it is further submitted that the prosecution has adduced evidence of several witnesses in support of its case, which could not be discarded by the defense. So the evidence of the victim is corroborated by other witnesses as well as by medical evidence. So the prosecution has established that the accused has committed the intercourse and has committed the said offence. So there was sufficient evidence before the trial court to come to the conclusion that the victim was minor at the time of alleged incident and the defense could not discard the evidence of witnesses to disprove the said fact. So it is submitted that the consent was immaterial as the victim was minor at the time of alleged incident. So both the courts have considered the aspect of juvenility of the applicant accused and the said claim was rejected by the courts below and the applicant accused is not entitled for the benefit under the provisions of Juvenile Justice Act. Stop the evidence in the form of school leaving certificate establishes the date of birth of the victim. Stop. She was born on 25th July 1981 and she delivered child on 23rd October 1996. Stop the evidence of victim, the medical officers, the headmaster of the school clearly establishes the case against the accused beyond all reasonable doubt. Stop the delay in lodging the first information report has been properly explained. Stop. There was no reason to disbelieve the evidence of the victim. Stop. It was not necessary to examine the author of general register. Stop. In these circumstances, no case is made out to set aside the impugned judgment and hence the revision application be dismissed. Stop. Learned APP relied upon the decision of Honorable Supreme Court in the case of State of Himachal Pradesh versus Sanjay Kumar alias Sunny reported in 2017. Stop. Since the applicant accused has challenged the impugned judgments of the conviction on merits as well as claimed applicability of the provisions of Juvenile Justice Act, it is tried to examine both the aspects. So, as far as merits of the case is concerned, it is a matter of record that the date of birth of the victim was 25th July 1981 and she delivered a child on 23rd October 1996. Stop. Whereas the date of birth of the applicant accused is 21st February 1978. Stop. The prosecution has examined several witnesses as stated above in support of its case. Stop. The trial court has opined that in the instant case, the express consent of the prosecutrix is silent